Okay, let's unpack this. We are diving deep into what was really, for nearly 2 decades, the foundational blueprint for traditional authority in South Africa. That's the Traditional Leadership and Governance Framework Act of 2003, Act 41. If you, our listener, are maybe studying law or history or even local governance in SA, this act is, well, it's kind of the starting point, because it represents the first really major post-apartheid attempt by the government to formally recognize and, I guess, integrate traditional authority within the modern democratic framework.
It really is a monumental piece of law. And its mission, basically, is trying to solve this constitutional paradox. How do you honor ancient custom and institutions' legitimacy, which, often relies on inherited authority, while at the same time forcing it to align with principles like equality, non-sexism, accountability, all demanded by the '96 Constitution.
Absolutely. And before we really jump into the details, we absolutely have to give the crucial legal context straight away. This act, Act 41, while it was central to how traditional governance worked from when it kicked off in September 2004, technically it's not the current law anymore. Sources are clear. It was formally repealed. The Traditional and Khoi-San Leadership Act of 2019 replaced it, starting April 1st, 2021.
Exactly. So what we're looking at today is essentially the scaffolding, you could say. The rule book that defined that relationship between traditional leadership and the democratic state for a whole generation. Our mission for you today is to really dissect this framework, give you a clear map of the hierarchy it set up, the transformation it demanded, and maybe most importantly, the political tensions it tried and, let's be honest, sometimes failed to resolve.
Okay, let's start with the big picture then. The constitutional stuff. The preamble of this act, it almost reads like a national statement of intent. It stresses that traditional leadership has to be fundamentally transformed, to line up with the Bill of Rights. So what were the core, the non-negotiable changes that were demanded of customary law?
Well, the demands were pretty far-reaching. They went right to the heart of customary practice, actually. The act specifically mandated that traditional communities must transform and adapt their customary law and customs. They had to ensure compliance with the Constitution. And this wasn't, subtle wording. It meant directly confronting any practices that promoted unfair discrimination.
And the focus on gender here seems incredibly powerful, particularly given, centuries of pretty entrenched patriarchal custom. What did the act specifically say about succession?
Yes, succession. It required traditional communities to actively seek to progressively advance gender representation, that was the exact phrase, in succession to leadership positions. That term, progressively advance, it was key. It sort of acknowledged that, look, instant change might not be practical or even possible, but it set this undeniable legal direction towards equality. It made promoting freedom, human dignity, non-sexism a formal requirement for any recognized institution's legitimacy.
So the very legitimacy of these traditional leadership institutions became legally tied not just to following custom, but to actively, contributing to the modern state's values. That feels like a huge shift.
It was a massive shift, exactly. They were also required to promote cooperative governance and strive for an efficient, effective, and fair system for resolving disputes internally. The act essentially turned traditional leaders into, constitutionally accountable public figures, even when they were exercising their customary authority.
Right. Let's pivot now to the internal architecture this act created. The structures themselves, they were this fascinating mix of old and new, weren't they? Formalizing things into clear legal tiers. What were the key layers of traditional governance the act actually recognized?
It meticulously defined 4 specific leadership positions, setting up a clear hierarchy, really for the first time in this way. Kingship or queenship at the top, then principal traditional leadership, senior traditional leadership, and finally headmanship. And crucially, a traditional community itself was defined as one recognized by the premier of a province, provided it was subject to a traditional leadership system and observed customary law.
Okay, so this structure established very clear lines of authority, defining who reported to whom, essentially.
Yes, precisely. A king or queen was recognized as having authority over multiple senior traditional leaders, usually covering a pretty wide geographic area. Then, a senior traditional leader exercises authority over a number of headmen or headwomen within their specific traditional community. That clarity was absolutely vital, for defining jurisdictions and making sure interaction with democratic local government could happen smoothly, or at least smoother than before.
Now let's talk about the administrative core, the traditional councils. The Act created this mechanism for putting these councils together that really tried to fuse customary rule with democratic ideals. That famous 60-40 split comes in here.
Ah, the 60-40 split. Yes, that really embodies the central tension of the whole act, I think. These traditional councils and the higher-level kingship, queenship councils and principal traditional councils, too, they were designed to blend that inherited authority with community participation. The composition was set at 60% selected by the senior traditional leader, based on custom, and the other 40% were democratically elected by the community members themselves.
Okay, but the question that always comes up is, why 60% selected by custom? Wasn't that percentage criticized for maybe entrenching the power of unelected individuals, potentially hindering that broader democratic accountability we were talking about?
That was definitely the ongoing debate, the political push and pull. Sources suggest that the 60% custom-based selection was seen as necessary, really, to protect the legitimacy of the institution in the eyes of the community itself, ensuring the council members were viewed as genuine representatives of customary law. But that non-negotiable 40% elected part, that was the state's way of guaranteeing some democratic oversight and accountability to the wider community.
And that's where that gender quota comes back in again, kind of overriding even the custom part.
Absolutely. Spot on. Regardless of how the 60-40 selection played out, the Act mandated that at least one-third of the total members of any traditional council must be women. This is a non-negotiable legal requirement, straight from the Bill of Rights. It transcended those customary selection rules and was designed to immediately start transforming the visibility and hopefully the influence of women in governance structures.
Let's move on to how leaders actually got recognized. This process really cemented that dual authority idea, the traditional authority of the royal family and the statutory authority of the state.
Yes, the process itself starts and ends, theoretically, with custom, but it needs that state validation seal of approval. So the royal family identifies the person who qualifies, whether it's a king, queen, principal leader, senior leader, headman, woman, according to their own specific customary laws of succession. Then they have to formally communicate this identification to the relevant government official. That's the president for kings and queens, or the relevant premier for the other leadership levels.
So the royal family identifies, but the state gets the final stamp. What actually gives the state the power to step in or even refuse that recognition?
The power really lies in that satisfaction clause. The president or the premier formally recognizes the person through a notice in the government gazette and issues a certificate, but only if they are satisfied that the whole process followed customary law correctly. And crucially, that it also complied with all those constitutional requirements we've been discussing, like non-discrimination. This gave the state essential oversight, preventing the recognition of leaders identified through potentially unfair or discriminatory processes.
Okay, and the flip side, the accountability mechanism is equally dual, isn't it? What criteria allowed the state to actually intervene and remove a recognized leader?
Right. The criteria for removal fell into sort of two main categories. One was based on failures relating to modern governance standards, and the other based on customary failures. So grounds included being convicted of a serious crime, specifically one resulting in imprisonment for more than 12 months without the option of a fine, or physical or mental incapacity. But that had to be supported by acceptable medical evidence.
And what about the customary rules? Because that seems like where the real potential for conflict lies.
That's exactly right. A traditional leader could also be removed for, and I quote, a transgression of a customary rule or principle that warrants removal, end quote. Now, this is where the tension really shows up. The royal family first has to decide to remove the leader based on custom, but then it's the president or premier who actually withdraws the certificate of recognition. So what happens if the royal family votes to remove someone for breaking a customary rule, but the state official looks at it and questions whether that customary rule itself is fair or constitutional?
It sets up a really complex legal battle, doesn't it? The state has to respect the customary institution, but simultaneously uphold the Constitutional Bill of Rights. It sounds like a real tightrope walk.
Precisely. It's a delicate balancing act. The process requires the state official to withdraw the certificate, yes, but only after being formally informed by the royal family. So the power is shared, ensuring neither side can just act completely on its own.
Right. Now, when we talk about the practical implications, we need to look at what these traditional councils were actually tasked with doing under the Act. Beyond just administering custom, how are they plugged into the democratic system?
Their function was expanded massively, actually. Traditional councils were essentially mandated to become partners in local development. Sure, Core functions included promoting indigenous knowledge systems and administering community affairs according to custom. But perhaps the most significant task was their requirement for intense interaction with different spheres of government, really promoting cooperative governance.
And this brings us straight to that partnership with municipalities. This is where two quite distinct political systems have to somehow learn to operate side by side.
Yes. The Act strongly pushed for partnerships between the councils and the district or local municipalities based on mutual respect. This gave traditional councils a formal, mandatory role in supporting municipalities to identify community needs, and crucially, facilitating community involvement in the municipality's Integrated Development Plan, the IDP. That IDP is basically the roadmap for how local government operates and spends money. Councils could even enter into direct service delivery agreements with municipalities.
Wow, so the scope of potential roles that could be allocated to traditional leadership was incredibly broad then, covering everything from land management to social services.
It was almost comprehensive, yes. National and provincial governments were empowered by the Act to allocate roles to councils in a huge range of areas. Things like land administration, agriculture, health, welfare, safety and security, even registering births, deaths, and marriages, economic development, tourism, and yes, even education. It was a recognition, I think, that these institutions often possess deep local knowledge and sometimes existing infrastructure that the newer democratic government couldn't easily replicate, especially in rural areas.
Yet, despite this deep integration into government functions, there was a very strict line drawn when it came to party politics, wasn't there? Integrated into public service, yes, but kept out of the political fight.
An absolutely essential protection. Section 4, subsection 4, laid down a clear rule of political neutrality. A traditional council, and importantly its resources, could not be used to promote or prejudice the interests of any political party. This was really designed to shield the institution from becoming, a political football, while still allowing it to serve the state and the community.
Okay, finally, we absolutely must discuss perhaps the most powerful structure created by this act, specifically for resolving disputes. The Commission on Traditional Leadership Disputes and Claims.
Ah, yes, the Commission. It served as the ultimate sort of historical and customary referee. But it's important to note, before a dispute could even reach this powerful body, there was a strict multi-tiered pathway. It really emphasized internal resolution first. Disputes had to first be tackled and hopefully resolved internally by the traditional community itself, according to their own customs.
And if that failed, if they couldn't sort it out themselves?
Then it moves up the chain. If it remained unresolved, it was referred to the relevant provincial house of traditional leaders. If it still wasn't resolved there, it went up to the premier of the province. Only after all those layers were exhausted, only then could the dispute or claim be formally referred to the Commission on Traditional Leadership Disputes and Claims. This pathway really recognized the primacy of customary resolution, but provided that state safety net.
And the Commission's scope was just breathtakingly wide, wasn't it? Dealing not just with current issues, but with historical claims going back decades. Specifically, why does that date, September 1st, 1927, jump out so much?
That date. It's the historical anchor for the Act's attempt at restorative justice. September 1st, 1927 is the date the infamous Bantu Administration Act was promulgated. That piece of apartheid-era legislation fundamentally reorganized and often illegitimately imposed traditional leadership structures.
Yeah.
It often created or disestablished tribes, and yes, our sources use that problematic term, often in quotes in ways that just suited this segregationist state's agenda.
So the commission was set up to investigate and potentially right historical wrongs imposed by apartheid legislation, tracing claims back almost a century to 1927?
Precisely. It was tasked with investigating cases where there was doubt about whether a leadership position was established legitimately according to customary law. It looked at claims by communities wanting recognition maybe as kingships or principal traditional communities. It also dealt with the legitimacy of how those historical tribes or headmanships were established or even disestablished way back when. And significantly, it was also specifically empowered to deal with gender-related disputes concerning leadership positions, but only those arising after April 27, 1994, the dawn of the new constitutional era, ensuring those new principles were applied going forward and sometimes retrospectively within that time frame.
Wow. That was a true deep dive into the legislative scaffolding that really defined traditional governance in South Africa for nearly 20 years. We've seen how this act tried to achieve that incredibly necessary but also incredibly difficult balance, maintaining customary continuity while simultaneously imposing these crucial constitutional demands for transformation and equality, especially through things like the mandatory gender quota and that complex 60-40 council composition.
It really was a masterpiece of legislative compromise in many ways. It institutionalized traditional leadership in a new way, provided critical mechanisms for state oversight and accountability, and offered a formal pathway for resolving disputes, particularly, as we discussed, through the Commission's power to grapple with those deep historical claims dating back to the Bantu Administration Act of 1927. Its core principles, especially around trying to advance gender equality and pushing for cooperative governance with municipalities, they definitely set a powerful and lasting precedent. You can see how they deeply influenced the subsequent legislation, the 2019 Act, even though this specific act is now repealed.
And that leads us perfectly into our final provocative thought for you, our listener, to consider. If the Commission's mandate under this 2003 Act was so critical, so vital for resolving historical disputes reaching back almost a century, specifically tackling those wrongs codified back in 1927, what lingering, maybe deep-seated questions or perhaps unresolved community claims might still be out there now that the successor legislation has taken over? And what does that potentially mean for South Africa's ongoing and often difficult journey toward restorative justice?